Hello, everyone, and welcome to IPRI's podcast. Today, we're joined with a very special guest who's a renowned public international lawyer, Professor Attila Tanzi. Professor Attila Tanzi is the chair of the Implementation Committee of the 1992 United Nations Economic Commission for Europe Convention on the Protection and Use of Transboundary Watercourses and International Lakes. Thank you so much, Professor, for joining us today.
Thank you very much for having me.
Professor, we're here to talk about today on the international water law and its evolution. So, as someone who's spent a considerable amount of time dealing with international water law, can you trace how, in your opinion, water law has evolved over the last century?
Well, in the first place, I'd like to say that the evolution of international water law has very much paralleled the rationale of the evolution of public international law proper, in the sense of evolving from the conceptual stronghold of the principle of national sovereignty through a process of constraints, of self-accepted constraint over territorial sovereignty for the benefits, for the utilitarian reasons whereby sovereign nation states would accept constraints on their sovereignty. And let me say that international water law could be seen at its inception very much as a branch of international economic law, protecting economic interests of riparian states for purposes of navigation, trade, irrigation, and later energy production. The evolution of this connotation of the law into a branch of international environmental law has necessarily only later occurred throughout the late 60s, 1970s, whereby I would find it fair to say that international water law, which is now addressing not just water quantity issues in terms of water allocation between transboundary co-riparian countries, is addressing also water quantity issues. And if you look at the way international water law has been recently, or no longer that recently, consolidated in writing through two international multilateral conventions, as it is generally considered a consolidation of international customary law, incorporates international environmental law into the body of international water law.
Going from that question, so when we talk about that international water law looks at the quantity and quality of water that riparian states use, what are the main principles that govern the water sharing between transboundary countries?
Right. Certainly the principle of equitable and reasonable utilization is one such principle. And if I may tie up considerations in relation to your question to the previous question, the evolution of this body of law, the epitome of the rationale, mutually accepted rationale of international water law between two co-riparians is given by a rather acrimonious dispute over a transboundary river between the United States and Mexico. The issue arose in such acrimonious terms in 1896, and it took 9 years for the two countries to come to an agreement and produce exactly the precursor to the principle equitable and reasonable utilization. The Rio Grande dispute, in which this Secretary of State of the United States, Harmon, elaborated his soon-to-be-defeated theory of absolute territorial sovereignty. which was being countered by an unreconcilable claim by the lower Riparian, namely the absolute territorial integrity principle. There's no way the two absolute claims of ancillary elements to the principle of territorial sovereignty could work out. This was soon to appear to be a detrimental, self-detrimental situation for both countries, and leading to uneconomical consequences, compromising the national security of both countries, and it turned out practical, useful for each country to give up their absolute claims and come down to an agreement whereby such concessions would turn absolutely mutually agreeable and beneficial, so that they came down to the famous Rio Grande Agreement on the equitable utilization of the Rio Grande of the river for irrigation purposes. And ever since then, the principle of equitable and reasonable utilization has evolved throughout the decades in combination with the principle of community of interest, which was solemnly and authoritatively spelled out by the Permanent Court of International Justice, the precursor to the incumbent ICJ, International Court of Justice, in a case involving 6 countries in the Oder River dispute, 6 states over navigation. And the principle of a community of interest and the equality of rights of all co-riparians provided further conceptual legal basis to the principle of equitable and reasonable utilization. And when environmental concerns, water quality considerations became known through scientific knowledge, because there must have been environmental questions before they became known. But if you do not have the technical, scientific capacity to detect and realize the quality and environmental, ecological aspects of a problem, the problem cannot be tackled. But once awareness was accrued by members, stakeholders, members of the process, that was water diplomats, politicians and scientists, academicians and operators, then the equitable and reasonable utilization principle was, and the community of interest principle was merged and read through the no harm or harm prevention principle, which was developed as, perhaps if you look at the applicable law under Article 38 of the Statute of the International Court of Justice, which lists the sources of international law, it's the principle of harm prevention came into the international legal system as a general principle of law recognized by civilized nations, from the Latin Roman law principle, whereby you may use your own land or your own property to the extent that it does not harm that of your neighbor. Sic utere tuo ut alienum non ledes. So much so that this principle, which was enunciated in a famous case between the United States and Canada, the Trail Smelter case, a dispute that started in the mid-20s and ended right after the Second World War, the no-harm principle was enunciated, whereby the fumes that were emitted on Canadian territory causing significant harm downward because of the droughts and the winds coming southward from Canada affecting agriculture in the United States, the principle has evolved, having been repeatedly restated by the same International Court of Justice time and again, from its domestic provenance, has attained formally the international status of a general principle of international environmental law, and it has become part and parcel, and we may discuss it further of later, become part and parcel of the equitable and reasonable utilization of transboundary watercourses, to the extent that there may be no equitable utilization which causes significant harm.
Okay, because now you've answered my question that I was going to ask now, but you can elaborate on it further, is that a lot of international law scholars have also come up with the idea that the reasonable, equitable and reasonable utilization principle and the obligation not to cause harm principle kind of are contrary to one another, in at times tug upon each other. So one has to be superior to the other. And so from that angle, Professor, do you feel that the two of them can coexist mutually and complement each other, or there will be situations when one will be given precedence over the other?
Right, thank you very much, Maham, for this question, because I think it goes to the heart of the use and the service that the law can render to real politics. I think that the narrative whereby one principle would prevail over the other, and one being subservient to the other, is a sort of a way to stretch for individual unilateral purposes the law. Where, we start, and we have to start from the assumption of an inner consistency within the system, particularly in a system of law which has developed by way of customary law. And it would be illogical to imagine that states generally, without pinpointing one or the other, would have adopted conduct generally that would provide the factual basis for the evolution of a rule that would be inconsistent with another rule. Because you look at the conduct of states, their attitude, what we call it opinio juris, that is the attitude, in one way that would be consistent with another way. If that were to be the case, there would be no customary rule on the point. If the no harm principle were to be in conflict with the equitable and reasonable utilization rule, there would be no equitable and reasonable utilization rule, because there would have been some conduct which would have superseded the previous rule. So, in fact, if we look at the two multilateral conventions I mentioned to you before, the 1992 UN ECE Convention and the 1997 New York United Nations Convention, and the way the two principles have been codified in writing, there is clear language, drafting indications whereby equitable and reasonable utilizations is being crafted and drafted in terms so carefully drafted so as to incorporate the principle of no harm. In fact, if you look at Article 5 of the New York Convention of 1997, the principle of equitable utilization is drafted in terms of equitable and reasonable utilization and participation, in terms consistent with sustainable development and consistent with the environmental protection of the river. So there is no equitable and reasonable utilization if the utilization in question is at variance with sustainability, environmental sustainability, and the protection of the environment. And this is the 1997 Convention, Article 5. If you look at the 1992 Convention, its main aim in Article 2 is that of preventing or mitigating significant harm. So the principle of no harm seems to come first, but comes first not just logically, but in terms of drafting. So much so that the principle of harm prevention is drafted by way of referring to equitable utilization, because Article 2 provides for harm prevention by way of reasonable and equitable conduct. So that shows that from both perspectives, the 1992 and the 1997, the two principles are drafted and conceived as one being part and parcel of the other.
Perfect, because that's something that people have been struggling with to understand. And so from there, Professor, we now live in a time, because of climate change, that water scarcity threatens cooperation over transboundary water courses. And in light of water scarcity, countries are seen as more protective of their use of water and asserting their sovereign right over water that flows through their boundaries. So, in times of water scarcity, what role do you feel that international water law and its development over time can play to better the cooperation amongst riparian states, especially at a time when people are going to be more focused on protecting their own share?
Well, thank you very much for that question, Maham, because that gives me the opportunity to say what I believe is the obvious, but does not seem, for probably unilateral political perspectives, so obvious. It would seem easy to say, well, climate change is a change which requires change in the law. And I would rather say the contrary, for this very logical consideration, whereby the change in question we're talking about is an increase in the acuteness of a problem which requires an increase of importance of the existing legal framework. So if states have made some resort to international water law to solve their problems in times of less scarcity, they all the more should stick to the framework and put it to full fruition. And it is no accident that it is generally viewed as a taken amongst the legal and diplomatic water community that expressly the UNECE Convention of 1992, which is now open to participation outside Europe, and I talk about the pan-European configuration, which goes from Iceland to Kazakhstan, Central Asia, and now boasts participation from Latin America and Canada. And also yes, Africa. We have now 9 countries from Africa who have joined the UNECE Convention. Well, it serves the purposes of the implementation of sustainable development goals, with special regard, but not exclusively, with regard to Principle 6.5, Goal 6.5. So you see, the stricter and stricter abidance by the framework is the necessary approach to address climate change and climate change mitigation policies. So we don't want to change the law, we want to change the attitude whereby you would not abide by the law. Change the attitude, don't change the law.
And coming from that conversation is my next question, that how do you feel international water law has added to the development of international climate law and international environmental law that are now being built as separate areas of international law? Do you feel international water law has added to their evolution in a way as well?
Well, you could say that the development of environmental law has added sensibly to international water law. But once the international environmental law has been incorporated into the water law process, the actual working of the process has provided pilot projects, good practices, which are certainly leading the environmental law process. And I'm particularly referring to the application and development, or development and application of the international regulatory framework at the basis of international water law. And I have been referring so far to the consolidation of customary law through 2 multilateral conventions. But then you have a galore of bilateral, multilateral water agreements, and a new genre of sources, the operational policies of international financial institutions. Take the operation of water law, operation policies of the World Bank, to mention one. They reflect in writing those basic principles, and they are put to fruition and they apply in practice. So much so that if a state abides by the international regulatory framework in this field, becomes eligible for international funding. That is what I call international water financial diplomacy as an incentive for compliance with international law. And I think this is a very good example which is being taken in other areas of application of environmental law, because it is working easily with regard to water law, which involves infrastructural projects which deserve and require, or first require and then may deserve, international funding, both at the public level or private level. So you have the World Bank, other intergovernmental financial agencies, but then you have the correspondent financial institutions which, under a framework, international regulatory framework, caters to private investors, such as the International Financial Corporation. And they all go by international environmental standards that have to be abided by states who are possibly becoming recipient of international funding, or private corporations that become the recipient of international funding.
Great. I think now I'm going to just move on to my last question, which is that international water law we've seen develop. We've seen the Helsinki rules, the Berlin rules, the Campion consolidation, and then finally the United Nations Convention on the non-navigational uses of watercourses, the 1997 one. So now where international water law stands, do you feel that there is still room for improvement as to look from a futuristic point of view of the development of international water law, or do you feel that international water law is developed enough and more states now need to become signatory to the existing conventions and buy into the international legal framework for water that has developed?
I suspect that your instinct, from what I gather from the way you drafted, you put your question, you got it right. I mean, lawyers tend to be happy to get engaged into development of the law. But I don't think there is much development needed here, as much as enhancing its implementation and working on frameworks for implementation, institutional frameworks. And one such framework, if I may compare, I think it is pertinent to your question to compare the 1997 Convention of the United Nations with the 1992 Convention. You would say, what was the need to negotiate a new convention? Is it developing anything that had been drafted in 1992? Well, there was merit. It was the drafting of the very general principles, but the New York Convention is just a basic text enunciating customary law, which you can either comply with or infringe upon. We know what is right and what is wrong. If you look at the UN East Convention, and that shows the usefulness of its opening worldwide beyond the pan-European region, is that it sets out the basic rules of the game, but it sets up also the institutional cooperation framework within which the existing law may be applied in an assisted way, in the sense that you have a meeting of the parties, and that makes international water law joining more and more and being in the forefront of the environmental law process, where states are not just left alone with a command, which they may comply with or infringe upon. They become parties to some kind of an institutional family, which is being participated by a large spectrum of shareholders, including financial agencies, and the secretariat, experts, scientific experts, a tremendous amount of interdisciplinarity where water lawyers, water diplomats, and scientists work back to back in order to enhance the level, the quality of application and implementation, which is a technical issue, but when it becomes successful, it becomes politically highly important. When you have regional, sub-regional water cooperation, you engage into a virtuous process which is not virtuous in and of itself for the sake of it. It becomes economical, it saves a lot of money, it becomes a means for security, and security can also be an economical value. You know how much one spends in terms of human resources, financial resources, in order to build up national security when you are insecure. So enhancing security is also an economic, political, and social value of itself. So let's go for enhancing implementation rather than developing new rules that may be seen even more difficult to be complied with.
I feel like the current rules are sufficient to find common ground on, considering the world we live in, where we want states to move towards multilateralism. And that's that. Thank you so much, Professor, for joining us and for a very enlightening conversation on international water law. We hope to see you in our future podcasts. Thank you.